Thank you so much, Ms. Wells. I will now call this meeting to order. This is the April 9th meeting of the Senate Judiciary Committee. It is our first committee passage deadline day, so we are getting started a little bit late. I want to acknowledge that and thank everybody for their patience. I also want to make it very, very clear that it is not the fault of our amazing, fantastic, accommodating staff who have been working almost literally through the night to get all of these work session documents completed. When I last looked, there were 94 pages of bills, amendments, explanations, and other materials. So I just want to express now my thanks to them and want you all to know that they have been absolute rock stars in turning things around in record time, sometimes multiple amendments on the same bill coming in before one email was even processed. So with that, we are going to work session a lot of bills today. I think we have 11 on our agenda. We're going to go one by one. Of course, with all of the committees meeting today, we will have people popping in and out to answer questions, but all of our committee members should be here the whole time. And for that reason, we might have to have some flexibility if we get to a bill and the subject matter experts aren't here and we have questions for them, we can come back to it, but we will try to get through them as quickly as possible. And as a reminder, we do not take testimony during work session. I do understand that there are a number of people who are watching and or listening, and that is great. And we appreciate you being part of this process. The work session is not a time to relitigate the bill or to grill the presenters. It is time for us to determine whether or not we want to pass the bill out of committee or not. And for those bills that have amendments, it is our opportunity to ask the sponsors of the amendments about those. I think that covers all of the preliminary information that I wanted to get on the record, and I will ask the esteemed secretary to please take the roll.
Vice Chair Cannizzaro.
Here.
Senator Orenshaw.
Here.
Senator Harris.
Senator Harris is on her way. Please mark her present when she arrives.
Senator Settlemeyer. Senator Hansen.
Here.
Senator Pickard. Chair Scheibel.
And I am here. I also wanted to let everybody know or check in with everybody. Our amazing committee manager, Beth Rikers, hand-delivered your work session documents to all of you. They're also available on Nellis, so hopefully we have no trouble accessing them. And we are waiting on a couple of members, actually, who I think are presenting in other committees. We're going to take a pause. We're not even going to go to recess. We're going to take a 30-second pause.
Madam Chair, or Chair?
Sure.
This is Senator Settlemeyer. I know that Senator Pickard is not available, and if you're waiting on him, don't worry about it. It is what it is, but I just want to make sure you knew that. Thank you.
Okay, thank you. All right. We are back on track. If the secretary could please mark Senator Harris present and Senator Pickard absent, we can get started on our work session. I will turn it over to you, Mr. Guinan, to start us off on SB 6.
Thanks, Chair Scheibel. For the record, Patrick Guinan, Committee Policy Analyst. As the Chair mentioned, we're beginning the work session today on Senate Bill 6, which is a committee bill brought on behalf of the Nevada Supreme Court. And the committee just heard this bill on April 8th, so I imagine you're familiar with it. The bill removes the ability of a family household member to file an application for an extended protective order, and custody of a firearm is removed from the list of factors a court may consider when determining if a person poses an imminent risk to themselves or others. Courts may consider additional information to that contained in an application for an order and are not required to hold a hearing on an application. The bill also provides that a firearm must be surrendered to the law enforcement agency of the officer that filed the application for the order, and the adverse party must supply a receipt for the surrender to the court within 1 business day. On the dissolution or expiration of an order, the court must issue an order for the return of any surrendered firearm, and a law enforcement agency must return it within 30 days. A court is required to dissolve an order if all parties stipulate rather than agree to the dissolution on a finding of good cause. Provisions governing hearings held by telephone are revised. And if certain conditions are met, a court is authorized to issue an extended order in lieu of determining when, whether to issue a temporary order. The term ex parte order is replaced in the bill with temporary order, and the new term must be interpreted in the same manner as the previous one for judicial interpretations entered before this bill becomes effective. And finally, provisions requiring a court to supply certain information to the adverse party or family or household members who file an application and to assist in other ways regarding an application are removed. There is an amendment which was developed in consultation with the court and presented by, and other stakeholders, I should say, and is presented by Chair Scheibel today. And I will just run through that briefly. It's attached to this document for your review. The amendment changes temporary in the bill to emergency, which replaces ex parte in statute for the purposes of this bill. It retains the ability of a family or household member to file an application for a protective order, but requires a showing of imminent risk to the person or others. It removes the distinction between an ex parte order and an extended order, and instead requires a single application for an order for high-risk protection. It adds to existing requirements for an application a requirement to include any supplemental documents or information, and establishes procedures for a hearing on an application, including the hearing must be held within 1 judicial day of the application filing. The court may issue an emergency or extended order, schedule a future hearing, or dismiss the application. The court may hold a telephonic hearing on an application filed by a law enforcement officer, and a court is prohibited from issuing an extended order at a telephonic hearing. The amendment also states that if an emergency order is issued, it expires no longer than 7 days after the filing of the application. The court must hold a hearing during this time period to determine whether to issue an extended order unless the emergency order is dissolved prior to that deadline. The court may extend an emergency period for 7 days to effectuate service of the order or for good cause shown. The amendment further states that if a court schedules a future hearing, it must be held within 7 days of an application filing, and the court may issue an extended order under certain circumstances. And lastly, the amendment states that if an extended order is issued at a hearing, it expires not later than 1 year after issuance. That's all I have, Chair Scheibel.
Thank you so much, Mr. Guinan. And I do want to clarify for the committee that this is the same amendment that we reviewed yesterday when we heard the bill. And now it's time for questions. I see Senator Settlemeyer's hand. Go ahead.
Chair, I know that it's going to surprise you, but I guess NRA is in opposition even if things are changed. But my major crux is something that Judge Bell stated on the record she was okay with, which was the concept of leaving it at 30 days. I don't have a problem with the bill, and I want to support the bill. I do have a question of the concept of waiting an additional 15 days to return someone's property to them. So in that respect, if you would allow, as part of the amendment, what Judge Bell indicated is okay, which is leaving it at 30 days, I'm pretty sure you'll have an unanimous vote out of this committee for this bill, and I want to be able to support it. I don't want to be partisan. I would like to have the amendment be 30 days, left at that, and we get along. Otherwise, if you're going to have to, I don't want to do it that way. I'm just hoping that you'll be able to go along with the idea of leaving it at 30 days.
So, Senator Settlemyre, I appreciate that, and I would also like to see this passed unanimously and bipartisanly out of this committee. And I see your hand, Senator Hansen. What I wanted to explain is that I think that Judge Bell also mentioned that the original reason for switching that number to 30 days instead of 14 was actually at the request of law enforcement. They were having trouble turning around the property processing to return firearms in less than 30 days. So I'm not going to entertain a conceptual amendment today on that number without consulting them, but I will remain open to it. And I understand that's not what you're asking, but with that information, I hope that will inform your vote, knowing that I'm open to continuing the discussion, but not open to making the change today.
I appreciate that, Chair, but in the same respect, we could process it and we find out that it's wrong. We can go to 30 if law enforcement steps up. Because again, Judge Bell indicated they're talking 33 people. They didn't know, there was no evidence that they had any problem getting them back in that time frame. Yeah, everybody'd love more time. Everybody'd love more time to do your homework. We'd love more time, and that's why we don't begin on time around here. So I'm sorry. I was just kind of hoping we could find a compromise, but I understand. Don't like it, but I understand.
Thank you. And Senator Hansen, did you want to weigh in too?
Yeah, actually, I think Senator Settlemyre didn't mean to, but he said 30 days a couple of times. He actually meant 14. Like the law is currently. So just going to help him out on that when he was saying that. He meant to keep the law, the time frame that it currently is, rather than the extension to 30 days. So just want to help out there, Chair. Sorry, that's it.
I appreciate it. All right, any other questions or a motion to amend and do pass?
So moved, Chair Scheibel.
Is there a second? A second from Chair Cannizzaro. And any discussion on the motion? I don't see any, so let's go to a roll call vote, please.
Vice Chair Cannizzaro,
Yes.
Senator Orenshaw,
Yes.
Senator Harris,
Yes.
Senator Settlemyre,
Sadly, partisan, no.
Senator Hansen,
No.
Chair Scheibel.
Yes. With that, the motion carries to amend and do pass SB 6 with the amendment as reflected in the work session document. And I will reiterate my willingness to continue to discuss the bill. And I will assign the floor statement. Is there a volunteer? I will take the floor statement. And with that, we will move on now to SB 22.
Thank you, Chair Scheibel. For the record, Patrick Guinan, Committee Policy Analyst again. We're now on Senate Bill 22, which is another committee bill that was brought on behalf of the Department of Corrections. This one was heard by the committee on March 4th, and it addresses deductions from individual accounts and wages of an offender. Senate Bill 22 revises the order of priority of deductions the Director of Nevada's Department of Corrections may make from an offender's personal account within the prisoner's personal property fund or from an offender's wages to comply with the Nevada Constitution, such that deductions for victim restitution are prioritized over deductions for the fund for the compensation of victims of crime. The bill also reorders the priority of several other deductions in slightly different ways, depending on whether the deduction is taken from an offender whose hourly wage is equal to or greater than the federal minimum wage or is less than the federal minimum wage. In each instance where the priority of deductions is reordered, the bill retains the director's discretion to determine a reasonable amount for the deduction, in some cases requiring the approval of the Board of State Prison Commissioners, prior to implementation. There is an amendment that was provided by Chair Scheibel on behalf of the committee. It's attached to this document. The amendment retains the new order of priority for deductions contained in the original bill that the director may take from an offender's personal account or from an offender's wages. However, it provides that the director may deduct no more than 25% of any single deposit to an offender's individual account and no more than 50% of any single deposit from the wages earned by an offender. Additionally, the amendment requires the director to provide an account statement broken down by month to each offender, detailing the total amount in the account, the amount and date of each deduction and reason for the deduction, and the amount of any debts owed by the offender, including any outstanding restitution. These statements are to be provided to the offender at no charge twice a year. Finally, the director is to maintain a package program for each offender that is exempt from deductions and that may only be restricted under certain circumstances and at the director's discretion in relation to disciplinary segregation, administrative segregation, or for medical reasons. And that's all I have, Chair.
Thank you so much, Mr. Guinan. I do see your hand, Senator Hansen, and I want to let everybody know that this amendment does represent a consensus between the JRAW committee, which includes Plan and the ACLU and Return Strong, as well as NDOC. Both parties or all parties have seen this amendment. They're aware of this amendment, and they're all somewhere between neutral and supportive of the amendment. So I think it does reflect the best compromise that we could come to. And I'll go ahead and take questions. Senator Hansen.
Thanks, Chair. The question I have, actually, I support the bill. In this committee, we had a bill by Senator Neal about making sure that prisoners get paid minimum wage. I don't know, did we have that, or is that coming up at all, or? I don't see it on the work session, and frankly, no, okay. All right, never mind then. But yeah, I support that bill too. So anyway, thanks, Chair.
Thank you. Any other questions on SB 22? Senator Settlemyre. And I'm
Thank you,
sorry,
Chair.
we also have NDOC here to answer questions for you.
Sure. I was just going to ask for the record, a lot of this is trying to make sure we're in compliance with Marcy's law. The victims are entitled to a full and timely restitution per Marcy's law. And I appreciate your amendment trying to find a balance to that. Does the concept of the 50 potentially put us in jeopardy with that? Should we do, no, I know it sounds weird, but do 49 so there's no argument there? Or I just wanted to have legal or NDOC weigh in on that particular aspect. That's my only concern.
I am going to kick this question to you, Mr. Anthony, if you don't mind.
Thank you, Chair Scheibel. In reviewing the bill, no, I believe it would comport with the intent and the provisions of Marcy's law under the Constitution as written.
Appreciate that, sir. In that respect, not real comfortable with it, but I'd amend do pass whenever you're willing to take said motion, Chair.
Motion accepted. Is there a second?
Second.
I see a second from Senator Orenshaw. Any discussion on the motion? Seeing none, we'll move to a roll call vote on the motion to amend and do pass SB 22 with the amendment presented by the committee as reflected in the work session document.
Vice Chair Cannizzaro?
Yes.
Senator Orenshaw?
Yes.
Senator Harris? Senator Harris?
Yes.
Senator Settlemyre?
Yes.
Senator Hansen?
Yes.
Chair Scheibel?
Yes. And with that, the motion passes to amend and do pass SB 22. I will also take this floor statement. We will now move on to SB 94. If you would please walk us through the work session document. Mr. Guinan.
Thanks, Chair Scheibel. Again, Patrick Guinan. We're now on Senate Bill 94. This is sponsored by Senator Settlemyre, and the committee heard it on the 2nd of March. It relates to public highways, roads, and ways. Senate Bill 94 adds the term public way to statute and defines the term in relation to access to public ways in this state. The bill also provides that it is not a nuisance for an owner of private property upon which certain highways, roads, or ways are located to post a sign indicating that the property is private, so long as the owner also posts a sign indicating that the public may access the road or way. Property owner who suffers damage or injury due to the public's use of such a road or way may bring a civil action for actual damages and attorney's fees. Private property owner may erect a gate or fence across such a road or a way after applying for and getting approval from the governmental agency that has jurisdiction over the road or way. The government entity must determine that such a gate or fence will not greatly inconvenience the traveling public prior to approval. The bill also sets forth requirements concerning such fences and gates and provides that they do not constitute a public nuisance or violate existing law against obstructing a road, street, or alley. Senator Settlemyre has proposed an amendment that is attached to this document. It replaces the bill as drafted and instead adds new language to Section 1, providing that an unlocked gate does not in and of itself constitute a nuisance. And that's all I have on that one, Chair Scheibel.
Thank you. Any questions on the bill? All right. Is there a motion to amend and do pass?
So moved.
So moved by Senator Hansen. Is there a second?
Second.
A second from Senator Harris. Any discussion on the motion? All right. We will go to a roll call vote.
Vice Chair Cannizzaro,
Yes.
Senator Senator Orenshaw,
Yes.
Senator Harris,
Yes.
Senator Settlemyre,
Yes.
Senator Hansen,
Yes.
Chair Scheibel.
Yes. With that, the motion to amend and do pass Senate Bill 94 passes. Senator Settlemyre, would you like to take the floor statement?
Yes, thank you.
All right. It is yours. And that takes us to SB 143. Mr. Guinan.
Thanks, Chair. Patrick Guinan for the record again. We're at Senate Bill 143, which is a bill that relates to the care of children. It was sponsored by Senator Harris and Assemblywoman Hansen, who joined us briefly a moment ago but had to leave. This bill was heard on March 8th originally. Senate Bill 143 revises provisions relating to the abuse, neglect, and endangerment of a child, negligent treatment or maltreatment of a child, and the circumstances under which these terms may apply to a person who is responsible for the safety or welfare of a child. The bill prohibits a person who is responsible for a child from permitting the child to be placed in a situation where the child is likely to, rather than may, suffer physical pain or mental suffering due to abuse or neglect. Similarly, the bill revises the circumstances under which negligent treatment or maltreatment of a child occurs by adding and defining the term negligent supervision to mean the neglect or refusal to provide necessary care or control when able to do so. The term does not include, and a person does not commit abuse, neglect, or endangerment by allowing a child who is of sufficient maturity, physical condition, and mental ability to avoid substantial risk of harm to engage in certain independent activities alone or with other children. These activities include traveling to or from school or other nearby commercial or recreational facilities on foot or bicycle, playing outside, and remaining home unattended. In consultation with the stakeholders, Senator Harris and Assemblywoman Hansen have proposed a conceptual amendment that is attached on the following page. And a summary of it is here below, and I'll go through it. The amendment replaces the content of the original bill entirely and makes the following changes. It adds a section expressing the legislature's intent regarding these children and independent activities. It removes all references to negligent supervision in Section 1, creates a new Section 2, and adds to the Nevada Revised Statutes, Chapter 432B.020, a new sub 2C defining independent activities. It amends current Section 2 of the bill, creating a Section 3, and makes the following changes. It restores, quote, because of the faults and habits of, end quote, in paragraph 1. It deletes definitions of quote unquote blatant disregard, quote unquote negligent supervision, and quote unquote independent activities from paragraph 2, and it removes from the bill all references to negligent supervision. That's all I have. Chair Scheibel, I'm sure Senator Harris will answer questions if there are any. Thanks.
Great. Are there any questions on this bill or the amendment? I don't see any. Is
Sure.
there a motion? Oh, Senator Settlemyre, go ahead.
Thank you, Chair. I appreciate the work that was done by Senator Harris and Assemblywoman Hansen to look at some of the problems. I'm going to support it out of committee, no problem. I was just curious if somebody could weigh in on whether or not some of the DA's, I assume, with the gut and replace, that the DA's concerns have been addressed. I just was wondering if we could get that on the record or if anybody knew.
Thank you for the question, Senator Settlemyre. To you through Chair Scheibel. I don't quite feel comfortable representing the position of the DAs on the record. I do understand that they with some of the changes we were making in that criminal provision. And most of those changes, as you can see in the amendment, have been stripped out. And so it leaves that portion mostly intact. But I cannot represent their position on the record today.
I will
I appreciate that. Go ahead.
I will
Sorry.
butt in and say that John Jones from the Nevada District Attorneys Association's words to me are, "We're happy."
All right, then I can tell my DAs to beat him up if there's a problem. So therefore, amend to pass?
Yes, correct. I think Senator Hansen still has a question or comment, hopefully about the sponsors of the bill.
Very good. You read it. Well, actually, I want to thank Senator Harris. It was actually a unique team working together on this, and they did very well. My comment, actually, Assemblywoman Hansen was here earlier. Today, 37 years ago, we had our first baby girl. So she had her first daughter April 9th, 1984. So I wish she was here because she would like this as a parent. This is really trying to establish parental rights and get some reasonableness back in the law. So thank you, Senator Harris, for working with her. She was here earlier but had to go to a committee. So on her behalf, I'd like to thank you and DAs and all the people that have worked so strenuously behind the scenes to make this happen. Thank you, Madam Chair.
Thank you. And with that, I can't remember if we had a motion to amend and do pass yet. All right, we do from Senator Settlemyre. We have a second from Senator Hansen. Any discussion on the motion? Not seeing any, we will go to a roll call vote, please.
Vice Chair Cannizzaro,
Yes.
Senator Orenshaw,
Yes.
Senator Harris,
Yes.
Senator Settlemyre,
Yes.
Senator Hansen,
Yes.
Chair Scheibel.
Yes. And that means that the motion to amend and do pass SB 143 passes unanimously. I will assign this floor statement to Senator Harris.
Thank you, Chair.
Moving right along, we will go to SB 164.
Thanks, Chair. For the record, Patrick Guinan, Committee Policy Analyst. We're now at Senate Bill 164, which is sponsored by the Chair and Senators Harris and Orenshaw and Assemblywoman Illian. It was heard by this committee on March 30th, and it revises provisions relating to human trafficking. Senate Bill 164 provides that any person who is a victim of human trafficking, as defined in the bill, is immune from civil or criminal liability for several prostitution-related crimes the person may have committed as a victim of human trafficking. A law enforcement officer is prohibited from arresting or issuing a citation to a person who reasonably appears to be a victim, and if a person is arrested and determined later to be a victim, the charges must be dropped and the person released unless the person has been charged with other offenses that were not committed in the person's capacity as a victim. Law enforcement officers, prosecutors, and courts are to refer victims to available resources, programs, or services, and are to notify the appropriate division of the Department of Health and Human Services concerning the victim, depending on the victim's age and whether the victim is a vulnerable person. The bill also exempts an arrested person who is subsequently determined to be a victim of human trafficking from the requirement to be tested for exposure to human immunodeficiency virus. These provisions apply to offenses committed on or after October 1 of 2021 generally, and before October 1 of 2021 in the case of a person who has not been convicted before that date. Chair Scheibel has proposed an amendment, which is attached in a conceptual form on the following page. The amendment would replace all sections of the bill with new language requiring an interim study be conducted concerning sex trafficking in the state. And I would leave it to the chair to add to that. That's all I have, Chair Scheibel.
Thank you so much, Mr. Guinan. And I would like to take a moment to acknowledge all of the people who have put in so much hard work on SB 164. And I am very happy to present this amendment that suggests an interim study. I think that it was clear from my presentation and from the testimony that there are a lot of stakeholders who are very invested in fighting human trafficking here in Nevada. and a lot of perspectives on how to do that and what's effective. I also think that we don't have to come to an agreement. We already agreed that we want to utilize a victim-centered, but also data-driven approach. And I want all of you to know that in the week since we heard the bill, I have worked very hard and very long with law enforcement, with members of Metro, the Chiefs and Sheriffs Association, with SWAN, the Sex Workers Alliance of Nevada, with the Cupcake Girls, with the Coalition to End Domestic and Sexual Violence. And really what we learned was that we were not at a place yet where we could implement policy or where we could agree on policy. There are more conversations that need to be had. There is more information that needs to be shared. And that is why I am proposing to turn this bill into a study. And I am proud to say that all of the organizations I previously mentioned are now in support, including including Metro, including the DA's Association, as well as my original advocates, the Sex Workers Alliance of Nevada, the Cupcake Girls, and the Coalition to End Domestic and Sexual Violence. Happy to answer questions about it if you guys have any. Senator Settlemyre.
Amend to pass.
Second.
All right, we have a motion from Senator Settlemyre to amend and do pass, a second from Senator Orenshaw. Any discussion on the motion? Not seeing any, we will go to a roll call vote.
Vice Chair Cannizzaro. Vice Chair Cannizzaro.
Yes.
Senator Orenshaw.
Yes.
Senator Harris.
Yes.
Senator Settlemyre. Senator Hansen.
Yes.
Chair Scheibel.
Yes. With that, the motion to amend and do pass carries unanimously. Thank you to all the members of the committee who engaged with me on this bill and for your support. I will assign this floor statement to Senator Scheibel, I guess. And with that, we can move on to the work session on SB 165.
Okay, thanks, Chair. Again, Patrick Guinan for the record. We're now at Senate Bill 165, which is sponsored by Senator Kieckhofer. It established provisions relating to esports, and we heard it here on March 17th. The bill creates the Nevada Esports Commission within the Department of Business and Industry to regulate esports, which is defined as a contest of multiple players using video games. The bill sets forth the qualifications of duties of the commission, which is to consist of 3 members appointed by the governor. Each member serves a 4-year term, and the governor designates a chair from among the commissioners who serves a 2-year term. The governor also appoints an executive director who serves at the governor's pleasure. And the commission is to adopt regulations necessary to govern esports in Nevada for both hosts and participants of esports contests. Senator Kieckhofer discussed a conceptual amendment at the initial hearing, which is attached. That amendment would revise the makeup of the commission to expand the membership to 5 commissioners. It would loosen the technical qualifications of commissioners and remove the prohibition on commissioner interest in esports enterprises. It would require the commission to appoint a technical advisory committee consisting of esports professionals from various areas within the industry, including broadcasters, event organizers, judges, players, publishers, teams, and anyone else deemed appropriate by the commission. And the TAC would also provide recommendations to the Commission on Esports standards and sanctioning thresholds for incorporation into regulations to be promulgated by the Commission. Members of the advisory committee serve without compensation. And the amendment would also remove the $1,000 threshold for sanctioning of events by the Commission and leave sanctioning decisions up to the Commission. It would clarify that the Commission has approval authority when considering applications for registration. And it would extend the effective date of the legislation to July 1 of 2022 to give the Commission a full year to complete its initial work. That's all I have, Chair Scheibel, and I believe Senator Kieckhofer is with us today if anyone has questions.
Thank you, Mr. Guinan, and I share that belief that Senator Kieckhofer is here. Are there any questions? You came all this way, Senator Kieckhofer, just to stare at us, not ask any questions. Is there a motion on the bill? All right, that looks like Senator Settlemyre with what I assume is a motion to amend and do pass.
Amend do pass. I'm going to reserve my rights. I think Senator Kefauver's done a phenomenal job working this bill through. However, I think there's probably some negotiations still going on, I would assume. So amend do pass.
All right, is there a second? I see a second from Vice Chair Cannizzaro. Any discussion on the motion? Not seeing any, we will move to roll call vote.
Vice Chair Cannizzaro,
Yes.
Senator Orenshaw,
Yes, but I'd like to reserve my right to change on the floor, Chair. Thank you.
Senator Harris,
Yes, but I'd also like to reserve my right.
Senator Settlemyre,
Yes, with reservations.
Senator Hansen,
No, with reservations.
Chair Scheibel.
Yes. With that, the motion carries unanimously to, sorry, not unanimously. Motion carries to amend and do pass. And I will assign the floor statement to Senator Kefauver, if you would like. Great. That one is yours. And with that, we will move on to the next bill on our work session, SB 166.
Thanks, Chair. Patrick Guinan again for the record. Excuse me. We are now at Senate Bill 166, which is sponsored by the Chair. It revises provisions relating to crimes motivated by certain characteristics of the victim, and the committee heard this bill on March 15th. Senate Bill 166 removes a provision from law which requires that in order for certain penalty enhancements to apply to felonies committed because of characteristics of the victim, including race, color, religion, national origin, physical or mental disability, sexual orientation, or gender identity or expression, the perpetrator must not share those characteristics with the victim. Instead, this bill provides that the perpetrator may be punished by an additional penalty if the crime was committed based on the characteristics of the victim, which makes the standard for these crimes the same as the standard that applies in misdemeanor cases. The Chair has offered an amendment that's attached on the following page. It would add to the list of crimes to which the bill applies those found in NRS 202.448, which addresses making threats or conveying false information regarding terroristic threats, and NRS 392.915, which regards threatening a pupil or a school employee with bodily harm. And it would add those crimes to the statutory cause of action for damages resulting from certain criminal violations if the person was motivated by certain characteristics of the victim. That's all I have, Chair. Thanks.
Thank you, Mr. Guinan. And I want to clarify for the committee that this is the same conceptual amendment presented at the time that we heard the bill. Are there any questions? I don't see any questions, so is there a motion to amend and do pass?
So moved, Chair Scheibel.
There is a motion from Senator Harris. There is a second from Vice Chair Cannizzaro. And now we'll go to discussion on the motion, starting with Senator Hansen.
Thanks, Madam Chair. I mean, I made my points clear during the hearing on the bill, so I won't elaborate. I just think, just like everybody's supposed to be equal in the eyes of the law, I think all victims should be treated equally in the eyes of the law as well. So I will be a no.
Senator Orenshaw.
Thank you, Chair, and I appreciate your efforts to work with everyone, including the opposition that testified at the hearing. And you've made some very compelling arguments for the legislation. I'm going to support it today out of committee. I still have some lingering concerns based on the opponent's testimony at the hearing, and so I just want to reserve my right to potentially change on the floor, but I will be supporting it today.
Thank you. All right. We have a motion on the floor. We have had our discussion. We will go to a roll call vote, please.
Vice Chair Cannizzaro,
Yes.
Senator Orenshaw,
Yes.
Senator Harris,
Yes.
Senator Settlemyre,
No, with the reservations.
Senator Hansen,
No.
Chair Scheibel.
Yes. With that, the motion to amend and do pass SB 166 passes. I will assign this floor statement to myself. And that takes us to SB 203 on our work session. And I believe that we have Ms. Brazier here to answer questions if there are any. And or Ms. Eaglet, or perhaps Mr. Eaglet.
Did you want me to go through the bill, Chair?
Yes, go ahead. Thank you.
Okay. Thanks, Chair. Patrick Guinan for the record. We're now at Bill 203. The Chair mentioned this is a bill sponsored by Senator Don Darrell Loop, and it relates to civil actions involving certain sexual offenses against minors. The committee heard it on the 23rd of March. SB 203 eliminates the statute of limitations to commence a civil action to recover damages for sexual abuse or exploitation that occurred when the plaintiff was less than 18 years of age and for injuries suffered by a victim of pornography involving minors. It also provides that a person who employed, supervised, or had responsibility for the person who was convicted of a crime of sexual abuse or exploitation of the plaintiff is liable in a civil action if certain conditions are met, and if the person gained a benefit from or covered up the sexual abuse or exploitation, the person is liable for treble damages. In consultation with stakeholders, Senator Don Darrell Loop has proposed an amendment that is attached here today, and as the Chair mentioned, we have at least 2 experts in the room or virtually to discuss it, but I'll go through it briefly. The amendment suggests the following. And then Section 1, subsection 3, to delete the definition of sexual contact as is contained in the bill. Delete Section 2 of subsection 2 and add a new subsection 2 to replace with federal statutory language. An individual who is a victim of sexual abuse or exploitation may bring a civil action against the perpetrator or whoever knowingly benefits financially or by receiving anything of value from participation in a venture which that person knew or should have known as engaged in an act in violation of this chapter, and may recover damages and reasonable attorney's fees. The mere rental of a hotel room shall not constitute proof of benefit in any establishment having 200 or more rooms. It would amend Section 2, subsection 3 to add that a person who is liable had to have, quote unquote, knowingly participated. A person who is liable to a plaintiff under subsection 2 and who knowingly participated, gained a benefit from, or covered up the sexual abuse or exploitation of the plaintiff is liable to the plaintiff for treble damages. It would amend Section 2, subsection 3, adding the following sentence at the end: provided that the mere rental of a hotel room shall not constitute proof of a benefit in any establishment having 200 or more rooms. And it would add a new section that limits the liability created in Section 2 to a 30-year statute of limitations. And that is it, Chair Scheibel. Thank you.
All right. And I believe, as you mentioned, this amendment does reflect a consensus of the parties, and we have 2 people here to answer questions about it. And is that a question, Senator Settlemyer?
Yes, good. I was
Okay.
not familiar with the discussion during committee or when this happened, the concept of the 200 room limitation. So if you're the owner of a smaller establishment, 150 rooms, the concept of just renting the room, how does that relate? I'm a little bit, that doesn't make a lot of sense to me, saying that if you're a bigger hotel, no, you have a different burden. I don't know, it just seems kind of strange to me. So if someone could explain why that 200 room was picked, and is that common in other sections of statute? I'm a little confused by that. But as Don Darrell Loop says before, I'm confused easily.
Chair Tracy Eglett, if I may.
Please go ahead.
Thank you. Senator, the 200 room limit was determined to, we felt that the strip casinos and the ones that resort that fall under the Nevada Resort Association have their own protocol, their protections. We are in the top 3 states in the country, but the majority, I don't know that any of this happens in the Nevada Resort Association hotels, but it is these smaller hotels where these girls are taken. This is where we feel we'll get the most benefit, and that we feel that this is a good start.
I appreciate that. Thank you.
Yes.
Other questions from members of the committee? Is there a motion to amend and do pass? Looks like
Moved.
Senator Orenshaw has moved to amend and do pass. Second. There's a second from Senator Cannizzaro. And now we'll go to discussion on the motion, starting with Senator Hansen.
Thanks, Madam Chair. While I am as aggressive as anyone in trying to eliminate this problem, I'm very uncomfortable since this is a civil action and the burden of proof is pretty minimal, just preponderance of the evidence. To open this up to an unlimited time frame just seems excessive. Seems like the 20-year limit is much more reasonable. So while I'm anxious to see those types of people prosecuted, the civil action side of it makes me uncomfortable on that kind of open-endedness. So I will be a no.
Understood. Any other discussion on the motion? All right, there's no more discussion, so we'll go to a roll call vote on the motion to amend and to pass SB 203.
Vice Chair Cannizzaro,
Yes.
Senator Orenshaw,
Yes.
Senator Harris,
Yes.
Senator Settlemyre,
No.
Senator Hansen,
No.
Chair Scheibel.
Yes. And with that, the motion to amend and do pass passes. I would like to assign this floor statement to Senator Dawn Darrow Loop, even though she's not here. And so that is what we will do. And that takes us to our next bill, SB 218.
Okay, thanks, Chair. Patrick Guinan for the record again. We are at Senate Bill 218, which makes changes relating to property. It was sponsored by Senator Ratty, and we heard it on March 24th in this committee. Senate Bill 218 revises several provisions relating to residential rental property and landlord and tenant responsibilities, establishes independent definitions of security deposit and cleaning deposit, and revises how each of those are to be handled upon the initiation and termination of tenancy. The bill creates a mechanism whereby a landlord and tenant may agree to an inspection of the premises prior to a tenant terminating a rental agreement in order that the tenant may remedy any deficiencies that may cause a deduction from a security deposit, and sets forth provisions governing this process. It shortens the time period allowed for the return of a security deposit from 30 days to 21 days and authorizes a tenant to file a complaint for expedited relief for the return of a security deposit. The definition of normal wear is revised to include deterioration that occurs without any fault of the tenant. A grace period must be included in rental contracts for late rental payments, and the landlord is prohibited from charging a late fee until that grace period expires. An agreed upon rental amount must be disclosed in writing and printed clearly on any rental agreement. Additionally, rental agreements may not impose any fee, fine, or cost that is not expressly authorized in statute, and a landlord may not charge a fee for the submission of a rental application. An agent who serves eviction notices on behalf of an attorney retained by a landlord may not be the property manager of the premises in question. And finally, a rental agreement entered into before this bill becomes effective is binding and may be enforced regardless of the provisions of this bill. And I know that there has been a lot of work going on this bill, and in consultation with a whole lot of folks, I imagine Senator Ratty has proposed a conceptual amendment in a mock-up which is attached to this document. And I would also want to note that in addition to this first part of the amendment I'm going to go through, we just received an additional little bit of revision this afternoon. And so that's also summarized in this discussion. So I'm going to go through all of them if that's all right, Chair. And then I know we have some folks here who can answer questions. So the amendments do the following. In Section 5, they provide that a security deposit may be applied for cleaning if the unit is financed by a governmental agency. Section 6 provides that a landlord may not charge a fee for more than one rental application at a time and only for the actual cost of a background check. Section 7 removes the procedure by which a tenant can request an inspection of the premises prior to the termination of a tenancy. Section 10 provides that fees, fines, and costs must be disclosed prior to signing the rental agreement or the tenancy commencing, printed on the first page of any lease, and cannot be increased without a written 45-day notice. Section 12 provides that a rental agreement may not require payment of any fee, fine, or cost unless authorized by statute, or actual and reasonable and eviction fees may only reimburse actual costs. Section 13 provides that a security deposit may be applied for cleaning if the unit is financed by a governmental agency and no cleaning deposit was charged. And then the landlord may claim the cleaning deposit but no other amounts for cleaning. The landlord must provide an itemized accounting of a security deposit and the return remainder no later than 28 days after termination. And a failure to do so results in liability for the entire deposit and waiver of claim to the deposit. Section 13 removes a procedure by which a tenant can file a verified complaint for expedited relief for a security deposit. Section 13 removes the clear and convincing standard of proof in actions relating to deposits and the requirement of 3 written estimates. Section 14 provides that a change in property management necessitates notice to tenants that deposits have been transferred and that no new deposits are required. Section 24 provides that an agent of an attorney may not be a property manager of any property in the state. So and then the next revisions that we received a little bit ago revise the bill as follows. Section 6, the landlord shall not charge a fee for the submission of a rental application other than for one tenant or group of prospective co-tenants for one available unit at a time. The fee must not exceed the direct and actual costs of the landlord, excluding personnel time and administrative costs. In Section 10(5) sub B, the following language is inserted, clearly and conspicuously printed as a summary accounting of fees with a total amount on the first page of any written rental agreement. In Section 10B, after 45 days, inserts in the case of any month-to-month tenancy or 15 days in the case of any week-to-week tenancy. Section 14 sub 4 strikes immediately upon transfer and replaces it with within 7 business days. Section 13 sub 6 replaces the phrase 6 months with the phrase 8 months. And next the amendment adds a new section 28 and revises NRS 73.012 to read as follows: representation of non-governmental legal or commercial entity by its director, officer, or employee and agent of the landlord. Sub 1.1, a corporation, partnership, business trust, estate trust, association, or any other non-governmental legal or commercial entity may be represented by its director, officer, or employee in an action mentioned or covered by this chapter. And 2 sub 2, a landlord may be represented by a landlord's agent in an action mentioned or covered by this chapter. So that is the sum of the proposed amendment from Senator Ratty, Chair Scheibel. Thank you.
Thank you. And we have Senator Ratty along with Bailey Bordelin here to answer questions. I already see a hand from Senator Hansen. Go ahead.
Thanks, Madam Chair. I missed a little bit of that. Could you have Mr. Guinan do that again for us, please?
No.
I'm kidding. No, look, honestly, there's some aspects of this bill that I really think are great. There's some that I'm really totally confused on now, frankly. I was a strong no on the original bill. A lot of this stuff has been cleaned up. So just, Chair, I am going to vote no, but I reserve the right to change, obviously, because like I said, I think this actually goes a long way in a very positive direction. I think there have been some abuses by landlords over the years. I think that's very well documented. So, but I'm totally confused at this point, frankly. So I'm going to vote no, but just wanted to let you know why. Thank you.
All right, any other questions? I don't see any. Is there a motion to amend and do pass?
Chair Scheibel.
Right. We have a motion from Majority Leader Cannizzaro. We have a second from Senator Orenshaw and also Senator Harris. And is there any discussion on the motion? I don't see any discussion, so we'll go straight to the roll call vote, please.
Vice Chair Cannizzaro?
Yes.
Senator Orenshaw?
Yes.
Senator Harris?
Yes.
Senator Settlemeyer? Senator Settlemeyer?
No.
Senator Hansen?
No.
Chair Scheibel?
Yes. With that, the motion to amend and do pass carries. And Senator Ratty, would you take the floor statement? Thank you so much. This takes us to our next bill on the work session. We will open up the work session on SB 219.
Thanks, Chair. Patrick Guinan for the record. We are on Senate Bill 219, which was sponsored by Majority Leader Canizaro, and we heard this bill on the 2nd of April. It relates to offenses. The bill removes a court's authority to suspend a driver's license or prohibit a defendant from applying for a driver's license as the result of any delinquent fine, administrative assessment, fee, or restitution the defendant owes. In regard to suspensions or delays imposed for the reasons named above, as of October 1, 2021, the Department of Motor Vehicles must reinstate the driver's license of a person who is subject to a suspended driver's license for the ability of a person to apply for a license who is subject to a delay in the issuance of a license. And it must notify the person of this change as soon as possible. DMV may not charge a fee for reinstatement of a license or require a person to undergo any physical or mental examination to be eligible for reinstatement of a license. There are no amendments. Chair Scheibel.
Thank you. Are there any questions on the bill? I see one from Senator Hansen. Go ahead.
Thanks, Chair Scheibel. Does this in any way impact child support suspensions? I know that the courts, I think under current Nevada law, can suspend people who are delinquent or deliberately behind in child support payments. Would this impact that in any way?
Thank you for the question, Senator Hansen. Nicole Canizaro, Senate District 6. I do not believe so, because this is a different statutory provision that deals with the non-payment for court cases, but it's different from the child support enforcement mechanisms. I may be legally wrong on that, so Mr. Anthony wants to correct me, but I don't believe so.
Thank you, Chair Scheibel. Yes, Senator Canizaro is correct. Child support provisions are separate and apart. This applies to any fee, fine, or administrative assessment relating to the underlying action. So Chair Canizaro was correct in her analysis.
Thank you, Madam Chair. One other point. I agree completely with the Majority Leader Canizaro. If you get a ticket for $500, the judge doesn't then ask you whether or not you can make payments. You just kind of face that possibility, and I think that part of the bill is completely accurate. I'm just uncomfortable with getting rid of the discretionary aspect where a judge can suspend it when they willfully cannot pay, when they intentionally avoid it. I'm very uncomfortable with eliminating the idea that they can use community service for people that have an inability to financially pay for their violations of the law. So I'm gonna vote no, but I do see some elements of it that make a lot of sense, honestly.
Okay.
Chair, if I may, I appreciate that, Senator Hansen, and I don't necessarily disagree with you on some of those. With respect to community service, I think the court has the ability to order that anyway in lieu of a fine, if somebody couldn't pay a fine. And I would note for the members of the committee, this is still a bit of a work in progress as we're trying to work with the DMV and make sure that this is with the DMV and also with the courts of limited jurisdiction to make this a workable policy. So I think there's probably still a few tweaks that we need to make, but appreciate the comments.
All right. Any other questions? Is there a motion to do pass? All right, we have a motion from Senator Orenshaw, do pass. We have a second from Senator Harris. Any discussion on the motion? We will go to a roll call vote, please.
Vice Chair Canizaro,
Yes.
Senator Orenshaw,
Yes.
Senator Harris,
Yes.
Senator Settlemyre, Senator Settlemyre,
No, with reservation. Sorry about that.
Senator Hansen,
No.
Chair Scheibel.
Yes. And with that, the motion to do pass SB 219 carries. Senator Canizaro, will you take the floor statement? Excellent. Excellent. That takes us to SB 317. If you would go ahead, Mr. Guinan.
Thanks, Chair. Patrick Guinan for the record. We are now at Senate Bill 317, which this committee heard on April 8th. It's sponsored by Senator Orenshaw, and it relates to juvenile justice. Senate Bill 317 allows an employee of a Juvenile Justice Services Department who has been placed on leave pending the resolution of certain criminal charges to use any accrued sick leave, annual vacation, or compensatory time, and requires the department to award the employee back pay if the charges are dismissed, the employee is found not guilty, or the employee is not subjected to punitive action in connection with the alleged misconduct. The bill specifies that an employee is allowed not more than 180 days to resolve charges against him or her, which begins after arraignment. The bill's provisions apply to an employee who has a charge pending on or after July 1 of 2021 for an offense allegedly committed, on or after July 1, 2021 for an offense allegedly committed before, on, or after July 1 of 2021. With Senator Orenshaw's support, and in testimony on the bill that we just heard yesterday, the Nevada Association of Public Safety Officers proposed an amendment that is attached to this document. The amendment clarifies that the 180-day period to resolve charges begins after arrest rather than arraignment, and it deletes language allowing any employee to use accrued sick leave, vacation, and compensatory time while attempting to resolve charges against him or her. That's all I have, Chair Schreiber.
Thank you, Mr. Guinan. Before we go to questions, Senator Orenshaw, did you want to make any comments about the amendment or about the bill?
Yes, thank you, Chair. For the record, James Orenshaw, State Senate District 21. The amendment that you find in the work session document is the same amendment that was submitted yesterday during the hearing. I wish I could say that I have consensus among all parties. Unfortunately, I do not. We've had productive talks, and I think we've made progress, and I'm committed to continue working with all the stakeholders on this bill to try to reach consensus. But as of now, I don't, but I hope the committee will consider moving this forward and allowing me to keep working with both sides. I think that the ultimate goal of trying to protect these men and women who work with children and try so hard to help them when they are caught up in the delinquency system is very important, and I'm happy to answer any questions.
All right, it looks like Senator Settlemyre has a question. But you're still on mute.
I'm gonna figure it out someday. Sometimes you turn my mute button on and sometimes it gets all confused. I apologize. I appreciate the amendment. It goes after a lot of the crux. One of the other things that came up during testimony, people charged under 62G can't be around kids. Does this bill, did that part of it get corrected? We had DJJS, Jack Martin talking about that particular problem, or is that issue still unresolved?
To you and through you, Chair, to Senator Settlemyre, certainly I cannot speak for Mr. Martin or Mr. Wellahan. My goal with the bill is to try to make sure that if an officer is charged and then those charges do not result in the conviction, try to make sure that they're made whole. Because of course, everyone's innocent until proven guilty. And as I understand this, while those charges are pending, if they're active, there certainly is the power for them to be removed from their work duties. But again, I cannot speak for Mr. Martin or Mr. Wellahan. I know they testified in opposition yesterday, and as far as I know, they are opposed to this amendment, and I'm committed to keep working with them, and I hope that I can get the parties together. We did make some progress, and I believe that we can try to get there.
Thank you, Chair, for letting me ask a question. Thank you, Mr. Orenshaw, for continuing to work on it. I am concerned about any bill that would potentially allow people who could hurt kids to still be around. I'll support the bill out of committee, but then I'm going to reach out to Mr. Martin to follow up on this particular question, because that is my main concern, is the children's safety. Thank you.
All right, any other questions? Not seeing any, is there a motion to amend and do pass?
So moved, Chair Scheibel.
Second.
All right, we have a motion from Senator Harris and a second from Vice Chair Cannizzaro. Any discussion on the motion? We will go to roll call vote, please.
Vice Chair Canizaro,
Yes.
Senator Orenshaw,
Yes.
Senator Harris,
Yes.
Senator Settlemeyer,
Yes, with reservations.
Senator Hansen,
No, but hopefully we can get those last minute bugs worked out.
Chair Scheibel,
Yes. And with that, the motion to amend and do pass carries. Senator Orenshaw, will you take the floor statement?
Yes, thank you, Chair.
All right, thank you. And that brings us to our work session on SB 359.
Thank you, Chair. Patrick Guinan for the record. We're on Senate Bill 359. Which is a committee bill, and we heard it here on April 7th. Senate Bill 359 provides that if a fire or explosion occurs as the result of the unauthorized manufacturing or compounding of a controlled substance other than marijuana, the person who has engaged in such unlawful activity is also guilty of arson. Similarly, if a person unlawfully manufactures, grows, plants, cultivates, harvests, dries, propagates, or processes marijuana or extracts concentrated cannabis, and that activity results in a fire or explosion, the person is guilty of arson. In consultation with several stakeholders, Senator Canizaro has proposed an amendment today, which is attached, and it's also summarized below, and I'd be happy to go through it very quickly. First part of the amendment amends Section 1 of subsection 3 of the bill to read, in addition to any other punishment that may be imposed pursuant to this section, if a person violates any provision of subsection 1 by engaging in the manufacturing or compounding of a controlled substance other than marijuana, or by attempting to do so, and a fire or explosion occurs as the result of such manufacturing or compounding of a controlled substance other than marijuana, or an attempt to do so, the person is guilty of a Category C felony and shall be punished as provided in NRS 193.130. And then the second portion of the amendment amends Section 2, subsection 4. And that reads, in addition to any other punishment that may be imposed pursuant to this section, if a person manufactures, grows, plants, cultivates, harvests, dries, propagates, or processes marijuana in violation of subsection 1, or extracts concentrated cannabis in violation of subsection 3, and a fire or explosion occurs as the result of the violation, the person is guilty of a Category C felony and shall be punished as provided in NRS 193.130. And I would leave it to Senator Canizaro to add comments if she would like. That's all I have, Chair.
Okay. Do you want to make any comments, Majority Leader?
No, I just wanted to, I guess, thank you, the committee, for letting me present this amendment. I think it clarifies some of the pieces that we heard during the hearing about what degree of arson and then what sort of intent there would be, and rather just provides for a penalty for when a fire or explosion occurs.
All right. Thank you. Any questions?
Sure.
Senator Settlemeyer.
Thank you, Chair. I was just curious. I'm not as familiar, obviously, with criminal law. In that respect, what is the difference between a Category C felony versus the discussion that was had during the testimony of gross negligence?
So gross negligence would be a legal standard to show what kind of intent someone had. And then the Category C felony is just the punishment range. So in NRS 193.130, there are various categories of felonies, gross misdemeanors, and it provides for what those punishments are. A Category C felony, unless otherwise prescribed in that statute for that particular offense, is a 1 to 5 penalty with a corresponding, I believe it's $10,000 now, fine. And so ultimately, if somebody were manufacturing or attempting to manufacture or compound, let's say methamphetamine, there's a separate penalty already provided in this statute for that particular crime. But if it then resulted in a fire or an explosion, that would be a Category C felony, punishable between 1 and 5 years at the discretion of the sentencing judge.
Thank you. I appreciate the explanation. I support the concept. Thank you.
All right. Any other questions? Is there a motion? Did I already call for a motion? Is there a motion to amend and do pass?
Amend, do pass.
All right, we have a motion from Senator Settlemyre. We have a second from Senator Harris. I see Senator Hansen as well, but Senator Harris beat you to it. And is there any discussion on the motion? Don't see any discussion, so we will go to a roll call vote, please, on the motion to amend and do pass Senate Bill 359.
Vice Chair Cannizzaro,
Yes.
Senator Orenshaw,
Yes.
Senator Harris,
Yes.
Senator Settlemyre,
Yes.
Senator Hansen,
Yes.
Chair Scheibel,
Yes. And with that, the motion to amend and do pass unanimously carries. And Senator Cannizzaro, will you take the floor statement? All right. That brings us to the end of our work session. We have one item left on our agenda, which is public comment. But before we get to public comment, I just want to once again express my gratitude to every member of this committee. We are making it through our first deadline day. You guys have all been engaged in our hearings. You've asked fantastic questions. You have shown up. You have presented bills in front of this committee, and I'm very proud to work alongside you. And all of us, I know, I'm going to speak for all of us to thank the amazing staff at the Legislative Council Bureau, because you truly make us look, yes, you make us look as good as we do. And you all know our committee counsel, Nick Anthony, who is a brilliant legal mind and wrote many of these bills, some of them late in the night and in the wee hours of the morning, and we can never thank him enough. You all know our committee policy analyst, Patrick Guinan, who also prepared these work session documents late in the night and in the wee hours of the morning, and is always available to us to answer questions, solve problems, and put out fires. You guys might not know that Mr. Guinan is assisted by Julianne King, who is a tireless workhorse who has also helped us with all of these work session documents and other research that we've needed. We have amazing secretaries, including Pam King, Sally Ram, Pat Devereaux, and Gina LaCasha. We also have our incredible committee manager, Beth Rikers, and she is the reason that any of you ever get any documents on time or even close to on time. And she is the only reason that our agendas are ever published and we ever know what is going on. She has also personally saved me on multiple occasions as this committee has thrown me some curveballs. So I'm very, very appreciative to her. I also want to give a thank you to my legislative assistant, Kayla Lee, who takes on some of the attendant duties of being the assistant to the chair and makes sure that I get to talk to all of you and all of our stakeholders in a timely fashion. And we literally would not be here if it were not for broadcast. Jen Wells has been with us since the beginning, and those of you who join us online, I don't think get to see her bright smiling face when we get started every day, but she's always here early and ready to get us started, along with Sierra Ferguson. Both of them have been absolutely fantastic, solved every problem under the sun and more that I don't even know that they're solving. And Bryce Kyle, who helps us get testifiers onto the interwebs using the magic of the internet and the robots. And he makes sure that when people call in, they get in a queue and they get to give their testimony. And truly, without these people, we would not be able to function. I hope I did not miss anybody. If I did, I'll borrow a sentiment from Senator Spearman and say, assign it to my head, not to my heart, because I know that there are so many people in this building who have kept us all going, and we appreciate all of you. I couldn't think of a really appropriate or fitting way to express that gratitude except to do what I can to allow you a day off and not have committee on Monday. We will not have any meetings, or I mean, we'll have meetings, but not this one, not Judiciary. Brad Zahner, he runs our cameras. he's the reason I look so fantastic every day. And that all of your bright, shining, smiley faces make it to the broadcast. So thank you, Brad. And like I said, there will not be a meeting on Monday. There will be a meeting on Tuesday. We will publish that agenda when we feel like it. And I'm joking, we will publish the agenda ahead of Tuesday's meeting. But I do want our staff to be able to take a long break this evening and over the weekend. Maybe some of them will even take the day off on Monday. That's out of my control. But we do appreciate everything that you do. And before I forget, we will employ Mr. Kyle's services one more time to see if there's anybody here to give public comment.
Well, thank you so much, Chair Scheibel. Very much appreciate it. The phone lines are open and working. However, there are no callers to give public comment at this time.
All right. Well, thank you again for everything that you do. Thank you to everybody who has made this committee possible. And with that, we will be adjourned until Tuesday at 1 o'clock. Have a great weekend, everybody, and happy deadline day.